Thank you so much for all of you guys for joining us. I'm aware it's exam season, so I really appreciate everyone attending. We're really fortunate tonight to be joined by Lady Hale. Lady Hale was appointed as President of the Supreme Court, which she took up in 2017 up until 2020, becoming the only woman to be appointed to this position. She has been a trailblazer throughout her entire career. She was the first from her school to attend Cambridge University, where she studied at Girton. She was only one of 6 women in the class among 110 men, graduating with a starred first and at the top of her class in 1966. In 1984, she would become the first woman and the youngest person to be appointed to the Law Commission. In 2004, she became the first female Lord of Appeal in Ordinary. Having been a trailblazer throughout her entire career, she is a notable advocate for greater diversity in the judicial system and the need for the judiciary to reflect the diversity of the country. Thank you for joining us.
Well, thank you for having me.
Just on a stand-back format, I'll ask a few questions and then I'll hopefully give plenty of time to the audience. So I guess before touching upon your career, I guess in regards to recent developments, how concerned should we be about the Supreme Court in the US making decisions which may undermine the rights of different groups, especially with the relative strengths of the US Supreme Court in comparison to the UK?
Well, my own view is that we should be concerned for the United States if the US Supreme Court undermines the rights of particular groups. You may very well have in mind the rights of women in relation to what is suggested they're going to do about the decision in Roe against Wade. But we shouldn't assume that what happens in the United States happens in the legal system of this country. We have a very different justice system, a very different method of appointing judges, which is crucial, and a different method of handling issues of that sort. And so, as I say, I'm not sure that we should be too concerned for this country, but of course, some of us are very concerned for our friends in the United States.
I guess one thing which is striking about the case in the US is the fact that the draft opinion was leaked. How damaging is this to the US judiciary in regards to trust?
It seems to me extraordinary that it was leaked. I don't know of any previous example of that having happened, and no doubt there will be much weeping and wailing and gnashing of teeth in the Supreme Court. Whether it's damaging or not may, of course, depend upon what eventually emerges as the decision of the court. It may be that the actual decision is more damaging than the leak of the decision, but then on the other hand, it may not be. Only time will tell.
I guess you mentioned before about the appointment of judges, and I guess in the case of the US, the ideological composition of judges tends to be influenced by the president. How robust do you think our system of appointing judges is in comparison with the Judicial Appointment Commission?
Well, our system is completely different because the US system is nomination by the incumbent president, who nominates people who share his political affiliation. So everybody knows what the political affiliation of the various members of the court is. The confirmation hearings in the Senate have not, at least in recent decades, resulted in any overturning. Well, there have been one or two, but basically the president can get a candidate that the president wants appointed, not necessarily his first choice. Now, in this country, it all used to be done through the Lord Chancellor, a politician, a member of the government, and the Prime Minister. But in practice, it has not been done on party political lines since the Second World War. That was no doubt because when we had a Labour government after the Second World War, they could not possibly have found enough Labour professing senior lawyers to appoint to the House of Lords, so they didn't. And in fact, one of the people who was appointed was Lord Reid, who had been a Conservative Member of Parliament, which I think rather indicates that party politics doesn't exactly come into the appointment of justices, and didn't even when it was done by the Lord Chancellor and Prime Minister. Now, basically, it is done by an appointments commission, which is chaired by the President of the Court, has another senior judge on it, and then has representatives from each part of the United Kingdom. And there is not a lot that the Lord Chancellor can do, either to influence the choice or to reject the one candidate that the appointing commission puts forward. That's our pattern. The Lord Chancellor is not presented with a slate, as happens in Canada, which otherwise has a rather similar system to ours. He or she is only presented with one candidate, to which he can only say yes, no, or persuade me. And in practice, he has always said yes.
Has the Roe v. Wade case and recent developments revealed, I guess, any particular strengths of the judiciary in this country, especially relative to the US?
Well, the only thing that I might say is that if there were to be such a case, and of course there never would be such a case, because our abortion law is by Act of Parliament, and at least in Great Britain, it's by Act of Parliament. And so the role of the court in dealing with Acts of Parliament is much more limited than the role of the US Supreme Court in dealing with either state or indeed federal legislation. So it wouldn't come up. It did come up in relation to Northern Ireland, incidentally. We did have a case about the abortion law in Northern Ireland, which, until the UK government took a hand, was what the law had been in Great Britain before the Abortion Act of 1967. And we did have a case about that. But I think what one can say is that nobody could predict the way in which the justices would handle such a case on the basis of their political affiliations or indeed their religious beliefs. Because certainly the politics of the Supreme Court justices is not generally known. I mean, there are one or two justices where you can make a very good guess, but mostly our politics are not generally known, or even if we have any, and nor on the whole is our religious affiliation. Although again, sometimes it is, but it's not a matter of such prominence as it is, of course, in the US.
I guess I also want to touch upon your life and accomplishments. As I alluded to in the introduction, you've been a trailblazer throughout your life, from academia to your legal career. I guess, how did you manage it, especially in a male-dominated field? And what sort of impediments did you face?
Well, I don't know, because yes, when I started out, there were very few women in the law. There were very few women in Cambridge, because there were only 3 women's colleges and 21 men's colleges, which is the reason for the great imbalance in law students. But I was coming into the law at a time when more and more women were coming into the law. There was a much greater attention being paid in the 1970s to women's rights. It was the second wave of feminism, and all sorts of legislation like the Sex Discrimination Act, the Equal Pay Act, and a lot of other legislation was helping to improve the legal status of women. And along with that came a recognition in some quarters that we actually needed more women in positions like the Law Commission and on the bench. And so I benefited from that. I have a feeling that I actually benefited rather than was disadvantaged by my gender, given the particular point in history that I was making my way through the law. Of course, you always encounter some difficult people, but then that's life.
I guess throughout your legal career, what was the most important case as it pertains to upholding justice and promoting equality in society?
Well, there have been several important cases. I mean, obviously, the most important case with which I have been concerned was the case about the purported prorogation of Parliament in 2019. That was about upholding justice, I suppose, upholding the rule of law, principally upholding the rule of law. As far as equality is concerned, I've dealt with quite a few cases to do with discrimination. I can't think of one that in particular stands out. I've also dealt with quite a few cases that were there to look at things from the point of view of children and enhance the status of children in legal decision making, and one or two enhancing the status of women in legal decision making.
I guess you touched upon the prorogation of Parliament, which, of course, was a very, very famous case. How did you handle the magnitude of the case? Did you perhaps feel any pressure?
The pressure that we all felt was the pressure of time. I mean, we obviously had to take the case. We don't get any choice in these matters because there was a case in England which had reached one conclusion, and there was a case in Scotland which had reached another conclusion. They could not both be right, because one of them had said the prorogation is something that we cannot interfere with, and the other had said not only can we interfere with the prorogation, but the prorogation was unlawful, null and void. There's only one UK Parliament, it either had or had not been prorogued. So somebody had to choose which of those two solutions was the correct one. So, and we had to do it quickly, because were we to reach the same conclusion as the Scots had reached, well, then we'd had to do it quickly, because otherwise the whole purpose of the proceedings would have been pointless. In other words, we had to allow Parliament to get back together and continue its important role while it still had some time to do it. So that was the pressure.
I want to touch upon the diversity of the judiciary. You have advocated for the importance of greater diversity in judiciary to make sure it's a representative institution. How crucial is this in facilitating the function of the judiciary? Does a lack of diversity impede its function in any way?
You could say no, it doesn't. I mean, if you appoint the right people to be judges and they are intelligent, fair-minded, independent individuals, it doesn't matter that they all come from a relatively narrow section of society. And I am sure that deep down there are quite a lot of people, especially those who belong to that section of society, who think it's not a bad thing. But in reality, there are at least four reasons for thinking we need a diverse judiciary. The first has to do with democratic legitimacy of the judiciary. The law is there for everyone. Everyone should have access to justice, and everyone should feel that the courts where they seek justice are going to treat them fairly and properly, are their courts, not just some elite body which doesn't really understand where they're coming from, laying down the law for the rest of society. So I think that's the first and possibly the most important reason. Another reason, frankly, is the look of the thing. You know, the justice system is all about justice, fairness, and equality. And if various sections of society are visibly not present in the judiciary, it doesn't look as if the judiciary is embodying those values. There's also the fact that we now have very diverse people coming into the legal profession, more than half women, a substantial proportion of people from ethnic minorities, people with disabilities, people with different sexual orientations, people from different socioeconomic backgrounds, which I think is incredibly important. And we ought to enable all kinds of people to make progress in the justice system and reach the top, provided, of course, that they have the ability to do so. And there's absolutely no reason to suppose that they don't. And then the fourth reason is that, of course, from time to time, they may make a difference to the way in which cases are decided, because they bring a different background, experience, and perspective to the deciding of difficult points of law. So there are four very good reasons for having a diverse judiciary. But in purely functional terms, of course, it could function without diversity, and did for centuries.
How would you, you touched upon this, but how would you assess the progress the UK judiciary has made? And is there any specific areas where further institutional changes are needed in regards to diversity?
Well, I think the institutional structure is pretty sound in that we've got the Independent Judicial Appointments Commission with very limited political input into choosing the judiciary at all levels. And it is supposed to appoint on merit, but to take active steps to diversify the pool of candidates from which selection is made. So institutionally, that sounds fine. In practice, of course, one does tend to find, obviously I know more about gender issues than I do about the other ones, but as in all professions, we find that there is attrition of women at around the sort of 15 to 20 years seniority. And this is often because it is difficult for people with family responsibilities to combine those with the sort of career that has traditionally taken you to the top. The appointment system has to find ways of understanding that and recognizing that even if people haven't spent 22 hours a day, in the office or whatever, that they may nevertheless be very good candidates to be judges. And the Appointments Commission is aware of this and is doing its best, but it's a long and difficult job, because it's always easier to select the sort of people you have traditionally selected for that particular sort of job. QCs become High Court judges, barristers become circuit judges, solicitors become district judges. All sorts of people become tribunal judges, that sort of thing. It's much easier to do it, even subconsciously, that way, than it is to devise good and accurate tests of people's potential to be good judges. But I think they're trying hard, and there's been a huge change since we had the Judicial Appointments Commission, which is some sort of reason to be cheerful.
I think this will be the last question, and then I'll bring it to the audience. I guess as a last question, what is your advice for the next generation lawyers, especially aspiring lawyers who may come from underprivileged backgrounds?
Well, what I always say to people starting out in the law is that it's very important to find something that you enjoy. Don't just be doing it because your parents think that would be a good thing for you to do, or a nice steady job, or because you're going to make lots of money at it, which sometimes is the case and sometimes isn't. It's important to find an aspect of the law and legal work that you actively enjoy doing. You won't enjoy it all the time, nobody does. But if you enjoy it, that means that you will work hard at it. And if you do that, you will be the best you can be at it. And so that's the beginning. But the other thing I think is today's world is changing very rapidly. When I was your age, the assumption was we would go to the bar or become solicitors and we would stay with the same firm or in the same chambers for the rest of our career, unless as barristers we went on the bench. In other words, we had pretty steady career trajectory. I didn't. I've had a very varied career in the law, but that's comparatively unusual. But these days, people should think that they will have a varied career in the law. They will change direction several times, and that is something to be celebrated rather than deplored. And so the other bit of advice is that if an interesting opportunity comes your way, then even if it is a little bit scary and you're not sure that you can do it, nevertheless, grasp that opportunity and give it your best, because that will be the way to make progress and also have an interesting life.
Thank you for that. If you wish to ask a question, can you please put an X on the chat and I'll unmute you and you can ask the question yourself. I'll go to Gabriel Millen first. Let me just get the name. Sorry, it's 2 seconds. You should get a request to unmute.
Thank you. Can you hear me?
I can hear you.
Great. Thank you. I just wanted to ask, I mean, it's pretty clear that you're one of the most celebrated family lawyers in England. So I wondered, from your experience, has the paramountcy principle worked in your opinion? Do you think it struck the right balance?
Well, I'm bound to say yes to that, aren't I? I mean, what balance has to be struck? If you're dealing with the future of a child, well then what will be best for that child has to be your guiding principle. Now, there are lots of things that go into what should be best for the child, obviously, including the relationships that the child has with various significant adults and what those adults have to offer the child. And there's a lot of other things as well, including the risk of any harm to the child and whether there'll be harm from disruption, all the things that are sitting in the checklist in Section 1 of the Children Act. But I don't have any doubt about the paramountcy of the best interests of the child. Frankly, I wouldn't do, would I?
Thank you.
There are plenty of other people who might do, but I'm not going to do that.
What do you think about the criticism, that it's kind of just a way for judges to decide whatever they want, and they just, use the principle to decide the outcome they think is right?
Well, all judges try and reach the outcome they think is right. I'm sure you don't think that's a bad thing. I mean, it would be terrible if judges, well, actually, sometimes we do have to reach an outcome which we think is wrong, because that's what the law requires of us. But in this particular context, no, one is trying to reach an outcome that one thinks is right. But the good thing about the paramountcy principle and judging is that you actually have to explain yourself. You have to, you don't have mechanically to recite the checklist, but actually it's a huge help in going through saying, well, what do I think about each of these items? What does the evidence tell me about each of these items? And then how do I balance the different things? I mean, some of it has to do with the status quo versus the ideal, but the untested ideal. That's the biggest dilemma often. And trying to get both parents profitably involved in the child's upbringing, it can be extremely difficult. It's more difficult, actually, in practice, to get the parent with whom the child is not living to take a real interest than it is the other way around. But of course, all the cases are about they're wanting to take more of an interest than the parent with whom the child is spending most of the time is actually comfortable with. And how do you sort that out? Well, that is, of course, a problem. But the other one is actually the more common problem. So you can't always achieve the result that you think is going to be best for the child, because you're dealing with people. And people are agents. Children are agents as well. That's another thing we have to remember, that children are not just dolls to be passed from A to B. They are agents in their own right, and it's very important to take into account the way in which the child thinks and feels about the situation.
Thank you. I'm going to go next to Saifullah Shah. I want to request you on mute.
Thank you. Can you hear me?
I can hear you, yes.
Well, my question was, the term judicial activism has become almost a derogatory term recently by more conservative judges and commentators, especially in relation to contentious issues like ouster clauses. So in terms of the role of a judge, do you think there is something called judicial activism? And what do you think the role of a judge should be in interpreting parliamentary language and applying the law?
Well, two different things: interpreting parliamentary language and applying the law. So I believe that the role of the judge in interpreting parliamentary language is to interpret the language in accordance with the well-established principles of statutory interpretation. I'm not entirely sure how much of those are taught in your average law course. Certainly when I was reading law in Cambridge, we were taught nothing about statutory interpretation, had to learn it all later on. But there are quite a lot of rules. And of course, included in those rules are whatever rules Parliament lays down. So Section 3 of the Human Rights Act, which tells the courts wherever it is possible to interpret legislation compatibly with the Convention rights, is an instruction to go further than the purely literal meaning of the words, as long as it is possible, as long as it doesn't actually contradict what the words say. So it is our job to do our best to apply the principles. And the same is true when we are considering what the common law answer to something is. We're not making it up as we go along. We're trying to discern what the general trend of the principles established in the earlier cases is, and to apply them to a new situation as it arises. So that is what we are trying to do. Some people are more cautious than others, but there's no set pattern to this. I well remember Michael Kirby, who was a great Australian judge, saying that a particularly activist decision was the decision of the House of Lords in a case called McFarlane and Tayside Health Board. And this was a case where the House of Lords decided that if, as a result of medical negligence, you had a child whom you never meant to have and shouldn't have had, you couldn't get the costs of bringing that child up from the medical insurers in practice. Now, that was contrary to all the normal principles. If somebody does you a physical harm, you can normally get the consequential financial loss. There's no doubt that having a baby is a physical harm. And they decided, for policy reasons, which they invented, that this was not the right solution, and so they decided something else. Now, some judges would have said, if it's not thought to be the right solution, Parliament can always put it right. But these judges decided the way that they did. And so that could be regarded as an example of judicial activism. But equally, of course, it could be regarded as a different sort of example of judges looking at things in accordance with a particular philosophical approach to what was and was not harm, and how it should be compensated. One person's activism is another person's conservatism, actually. I think you could probably find that the most adventurous decisions are often in rather conservative directions, like the example I'm giving. So, but I also think you can't really generalize about individuals. I don't think we're any of us consistently of one sort of approach rather than another.
Next question is John T. Yin. You should get a request on you.
Hello. I hope you can hear me, Lady Hale.
I can definitely hear you. I can see you too.
Wonderful. First of all, thank you very much for your time today. I'm sure we really appreciate a break from exams to listen to you answer all our questions instead of answering questions ourselves. My question for you is in relation to the recent announcement in the royal speech that the government will be seeking to repeal the Human Rights Act in favour of a new British Bill of Rights. I think obviously quite a lot of students are concerned that that won't provide as much protection. Do you think that if the Bill of Rights is to provide less clear protection of the rights under the ECHR, that the jurisprudence developed by the court under the HRA will continue to have some effect?
That's a very good, precise question. Thank you. I have made no secret of the fact that I think that it's a mistake to be replacing the Human Rights Act, partly because any new piece of legislation is bound to throw up a huge number of questions which are going to cause an awful lot of bother. And one of the questions would indeed be, how relevant is the jurisprudence under the Human Rights Act to the new British Bill of Rights? That will, I think, depend, of course, on exactly what the British Bill of Rights says. I mean, in the consultation paper, the government said, we are going to remain members of the Council of Europe, we are going to remain signatories, as we have to do, to the European Convention on Human Rights, we are going to remain accepting the jurisdiction of the European Court of Human Rights. They have to. So all the rights which are in the European Convention will presumably still be in the British Bill of Rights, which rather suggests that unless there are specific provisions dealing with any of those rights, the previous jurisprudence under the Human Rights Act will remain relevant and indeed probably binding, unless and until it's overturned by higher authority. Of course, if the eventual act does legislate so as to require the courts to interpret particular rights in a particular way, well, then the courts will have to wrestle with that. And the experience that we've had with the previous attempt to tell the courts what Article 8 meant in relation to foreign national criminals was not a particularly happy one. But that was partly because the legislation was completely incomprehensible. We had to do our best with it. But that's a good example of how much trouble new legislation can cause. So we shall have to wait and see. And similarly, we shall have to wait and see what they do about Section 3, which is probably the most crucial question. They in the consultation paper, they said various contradictory things. So we shall see. Is that an answer to the precise question that you asked? I think it is an answer to that.
Thank you. Next person is Rosie Gilbert. You should get a request on mute.
Hello, can you hear me okay?
Yes, indeed, I can.
Thank you so much for talking to us today. It's been so brilliant. I was just really curious about your opinion on the new divorce reform, so the introduction of no-fault divorce, of course, and what you thought about it and whether you think maybe it's the end of innovation in the realm of divorce.
Well, it's almost certainly not the end of innovation in the realm of divorce, although some of the other proposals I am not in favour of. But I'm very much in favour of the new way of getting divorce. I think that's the way to put it, because it is in principle exactly what the Law Commission recommended in 1992. It's slightly more radical than that, because the waiting period is a total of 6 months rather than a year. But otherwise, the principle is, you say on day one, our marriage is broken down, or and then you say sort of 6 months later, our marriage is broken down, and that's it. And in between, you've got the possibility of getting the orders that you need to sort out the arrangements. So one way or another, it's exactly, in principle, what we recommended all those years ago. And one of the things I always say is never say never in law reform, because there are some ideas which are ahead of their time, but their time may eventually come.
The next person to ask a question is Lakar.
Hi. My one is then slightly more general off the back of those quite specific ones. Obviously, you brought up to the prorogation hearing earlier. I was wondering if, because of sort of the intense media coverage that had, do you think there's been have you noticed a change in the way that the Supreme Court is perceived sort of by the public and its sort of public presence?
I don't know the answer to that. I think that the Supreme Court came to public attention in a much bigger way than it had ever done before, and the House of Lords had ever done before, with the first of the Miller cases, because that did provoke really intense public scrutiny. And you know, the court was full, and we had to have a seating plan in the court and ticketing system to get into the overspill courts, and there were demonstrations taking place outside, and of course the whole thing was, all 4 days of it were televised, and so on. So I think that did put the Supreme Court on the map. And the Miller Cherry case was another example, but I doubt if it was any more prominent than the first one had been. So to the extent that it enabled the public to know what the Supreme Court was and what it did and how it did it, it seems to me to be a good and positive thing. But there are a lot of other things that the Supreme Court has done in order to make itself much more visible than the House of Lords was. I mean, it is easy to pop in from Parliament Square if you fancy it when you go past. Well, there are loads of, and you can always watch a hearing, and you can find out a lot of what's going on in a much easier way than you could when we were squirreled away in Committee Room 1 in the House of Lords. So I think that's all very positive, in fact. But of course, the other thing that those televised hearings demonstrate is how very boring our proceedings are, you know, unless you are closely involved with them and have got all the documents. And that's the thing I would like to see, that we could put the court bundle up on the website so that people who are interested could look at the documents. But there are all sorts of problems associated with that, and so we haven't yet found a way of doing it. But I think it was, on the whole, beneficial for the public to see, particularly in the first Miller case, which was the atmosphere was so very febrile, everybody said, that we were debating a thorny point of constitutional law very slowly and in great detail. We were not debating whether Brexit was or was not a good idea. we were debating how it should be gone about. And I think people understood that. So that was a good thing.
If anyone wants to ask a question through the call, please put an X in the chat. I guess one question which was submitted in written form pertains to Scotland. Two questions asked: do you think Scotland can gain its independence without Westminster's permission? And another question asks: does Scotland have a mandate for a referendum, given the huge change of circumstances and repeatedly voting?
I'm not sure how proper it would be for me to try and answer either of those questions. The technical position probably is, but obviously I haven't heard a case about it, that the Scottish Parliament could not legislate to have another referendum without the agreement of the UK Parliament. That's not within there, it's not within the competence. And so if they tried to do that, somebody would challenge it in the UK Supreme Court. And the odds are, I think, that it would be held that they couldn't do that. So the question is more a political one. When will the point come that the UK government and Parliament cannot properly deny to the Scots a second referendum, independence referendum, I think which is a political question rather than a constitutional question. Mind you, it might be thought by some that this is not a question that should be decided by the Scots alone, because the Act of Union said that this was a perpetual union. It was going to go on forever. And it might be thought, therefore, that both parties to that union were entitled, or all parties to that union were entitled to a voice in this. It's not the same as a colonial situation where a colony says it wants its independence. Then, of course, one sees that that is a matter for colonial self-determination, but that's not the position in the United Kingdom, especially of Great Britain. And so I think in sort of constitutional theory, there are reasons to suppose that it shouldn't be a matter for just a Scottish referendum. But there we go. I'm not saying that that's a position that I espouse, but I can see an argument that it should be a Great Britain-wide referendum. And who could predict how the English and the Welsh would vote in those circumstances?
Next question comes from Anita. You should get a request to unmute.
Hello, I wanted to ask if there was one particular area of law where you would really like to see immediate reform.
Oh, gosh. Immediate reform. Law reform is never immediate. Let me see. I've not thought about that for a little while. I think as a family lawyer, the most obvious reform which is urgently needed is to introduce financial remedies between cohabiting adults. And that's been urged by the judiciary, practitioners, the people involved for a very long time. And we've got a model in the Scottish legislation, which is relatively simple, although the Scots are reviewing it, as I understand it. Nevertheless, that's something that I would sort of take off the shelf straight away. There are no doubt a lot of other things that deserve to be done, but are not at the top of my head. I mean, I would like to think that the justice system could learn how to handle sexual violence and abuse, especially against women and girls, much better than it currently does. I don't have any easy answers to it, and it's more a systems question than the substantive law is probably since the 2003 Act. It's much better than it was before the 2003 Sexual Offences Act. So it's probably not a question of substantive law, but it is a question of legal processes. And they certainly need a thorough looking at and overhaul. You know, we've got these flip-flops between the police didn't look at a woman's mobile phone, but the defence did, and then the defence found things on the mobile phone which undermined the prosecution case. So then the police thought, well, we better look at the mobile phone and find out, which of course for most people was deeply intrusive and not necessary. And we've had a flip-flop between those just recently. And somebody's got to work out what the right answer to that sort of thing is. That's the biggest area where I think the justice system is letting down half the population, basically.
Thank you.
So one question that is that was submitted privately is whether Lady Hale has seen any value in marriage as a legal institution, given changes over time in terms of family types, increasing cohabitation, etc.
Well, the obvious answer to that is that as the law currently stands, yes, of course, there's a value in marriage as a legal institution, because it provides a set of mutual rights and responsibilities between the adults, which I happen to think are beneficial to the adults. It also provides a status which makes certain kinds of administrative activity a great deal easier than it is when you're also looking at people who are living together. If, of course, we were to assimilate the rights and responsibilities of married people with those of people who aren't married, well, then the necessity for marriage as a legal institution would be diminished, although I think it would still have its conveniences. The symbolic importance is quite considerable. But in any event, we're not going to have law reform which assimilates the rights and responsibilities of married people and unmarried people anytime soon. So I think it still does have a utility for the people involved, quite apart from for the rest of us. Helpful to know who is with whom.
I think that's all we have time for today. Once again, thank you so much, Lady Hale, for giving up so much of time and answering so many questions.
Well, it's always a delight to try and think up answers to the questions that bright young people ask me. And so it's nice to be with you. And you were very persistent in trying to get me to come and see you. And so many congratulations for your persistence has eventually paid off. And if those of you who are in the midst of exams at the moment, I hope that this has proved a welcome diversion.